Good afternoon, everyone, and welcome. I'm Kara Bloomberg. I'm the Chief Operating Officer of LandrumHR. Thanks so much for joining us today. We have 45 minutes to cover as much ground as we possibly can on return to work strategies and the important compliance factors that you need to consider. I can tell you we've been doing these webinars for about 6 weeks now on various topics related to the COVID-19 legislation, and our team was really excited to get this webinar started and talk about reopening businesses, as we have so many clients and businesses in our communities that we serve that have been almost completely closed down or totally closed down. So we hope that we can give you information today that will help you make the best decisions for you and point you to additional resources. Our website, LandrumHR.com, has information, updates, links. Amie's going to be talking about a lot of compliance legislation pieces, and there's more information on our website related to everything that she discusses today. And as a reminder, all of our attendees will receive a recording of this webinar. Many of you are clients, but for those of you that aren't familiar with us, LandrumHR is a nationwide human capital services company. We offer full service HR outsourcing or PEO services, worksite management and staffing solutions, and insurance. Our HRQ division provides human capital consulting, interim HR talent, and conducts searches for HR professionals across the country. You can find out more about all of our services by visiting our LandrumHR.com website and HRQinc.com website for more info. You can submit questions today through the questions pane on your control panel. We're going to work to get to many of those questions during our live Q&A session at the end of the presentation. So I want to get started with asking all of you a question. We have hundreds of attendees today, and we anticipate you're all in various stages of returning to work. And we wanted to start off by asking you a question about returning to work. So when do you expect your employees to return to work? This week, next week, by the end of May, or longer? Just take a couple of seconds here, and if you guys don't mind participating in the vote, we'd love to see, kind of where all of our attendees are in the progression of returning all their employees to work. And we do have, people across the country attending, so I know there's a lot of state legislation, even local legislation that goes into this. Okay, I'm going to go ahead and close this out. So looks like right now 44% of our attendees are saying by the end of May, closely followed by 24% that believes it's going to be longer, 22% next week, so that's great, and only 9% have employees coming back this week. So now I'll take a minute to introduce Amie Remington. She's our General Counsel at LandrumHR. She spent the last 15 years of her career here, and she has over 20 years of employment law experience. She's a national speaker on employment law topics. Amie, you've got a lot to cover. Let's get started.
I do. Thank you, Kara. We're going to talk today about returning to work. And in the past 6 weeks, we've done a series of webinars to focus on the life cycle of all business aspects related to COVID, beginning at talking about what COVID was and whether it might possibly disrupt our work, which sounds like a silly question in hindsight, right? But we're hoping that we're near the end of this cycle and that our clients and our communities are able to safely begin to reopen. And our goal is to help you navigate the decisions that you might need to make to reopen. The challenge for employers is the fact that there are no national policies governing reopening. Different states have different rules. For example, just this week in Georgia, gyms and fitness centers and bowling alleys and body art studios and restaurants and hair salons were allowed to reopen. Other states remain on a total lockdown. And so even within those states, there are varying rules for varying industries. So you have to know where your employees are, what industries they're working in before you can begin to make decisions. Employers need to balance practical and their legal issues. We're going to talk about both, starting with legal issues. And I firmly believe that most litigation can be preventive with good employer-employee engagement. I don't think that you can over-communicate with your employees, particularly now. We want employees to be productive and happy and safe. And so I think that there's no such thing as over-communication. So as we walk through today, bear in mind that all of the laws we're going to talk about are federal laws, but your state, whatever state you're in, probably contains a law that mirrors these different laws and may even expand the rights. And then finally, I want you to think today as we go through this beyond COVID, because preparation for and recovery from COVID is similar to preparation and recovery from other business interruptions, such as, like we know so well in the Panhandle, hurricane preparation and recovery. So I want you to think kind of globally at what we're talking about so that should you face some other business interruption, some of these tips might be helpful in the future as well. So let's start with a little good news. And the good news is that this is a great time for you to work with your insurance agency, establish that relationship, because you may have some insurance available to help you if you sustain losses, and you may not be aware that you have these policies. For example, I would sit down with if I were you, sit down with your carrier and ask whether you have a business interruption claim. Some business interruption claims provide for interruptions due to pandemics, others due to viruses, others due to epidemics. But it's good to go ahead and ask that question. And then if you're not convinced that the answer that you're getting is maybe the proper answer, or maybe it doesn't comport with what you believe the policy says, have a lawyer look at it and see if there's some other coverage. Like, for example, you may have a policy and not even be aware of what's called civil order language. And that's language that says if there's a civil order that requires stay at home, for example, you may have coverage for that. And of course, your EPLI, which is your Employer Practices Liability Policy, which provides coverage if there's a wrongful termination, a discrimination claim, or something like that. But you may be pleasantly surprised and find out you have insurance for business losses that you didn't anticipate. One area that we're going to follow closely is will employers be liable in any way to third parties, your customers, for example, for negligence or wrongful death, because the third party becomes ill or, heaven forbid, dies of COVID. And as you're thinking about that, I want you to think kind of cruise ships and those kinds of businesses. There's a theme in employment law, and I can't say this enough, and it's on every slide today, so I'm not going to repeat it 15 times, but I just want to say it in the beginning. In every employment law, one of the common themes is that there's no retaliation allowed. And what that means is that if somebody exercises a right that they have under federal law, that means that you cannot demote them, you can't reduce their pay, you can't reduce their status, you can't take any adverse action because they exercise their protected rights. So let's just bear that in mind, that that's a common theme in employment law for every single federal law that's out there that it protects employees. So let's start with the Fair Labor Standards Act, which of course is the federal wage and hour law. And every state has a mirror to this. It may look a little different, but basically the Fair Labor Standards Act, the reminder here is that there's no break in the Fair Labor Standards Act at this time. All regular rules still apply regarding payment of wages. Now, there was a non-enforcement period during the first couple weeks of April. And so if you did make a mistake during this period of time, you have a safe harbor, if you will, way to make a good faith correction. And to do that, you have to be able to show that you are ready to promptly remedy any violation that occurred during this time, that the violation wasn't willful. In other words, you didn't do it recklessly or intentionally. And you have to agree that in writing to the Department of Labor, that you will comply with laws in the future. So that's what the non-enforcement period is. So if you've made a mistake during this time, seek help from your HR professional to get those mistakes corrected. And that would be good news because the Department of Labor would come in and probably be very flexible during this time. There are questions that I've received quite a few of And the question sounds something like this. I've got an employee who's exempt, which means they aren't entitled to overtime. They're subject to one of the white collar exemptions. They're supposed to work 40 hours a week. I don't have 40 hours worth of work during this period. Can I make them a non-exempt period and pay them by the hour for this period only, and then turn them back to an exempt employee when things pick up? And the answer is that's a super, super risky proposition, because once you change somebody from exempt to non-exempt for the purpose of reducing their wages, you've probably destroyed their exemption forever, which means that you could make that change, but you would have to know that going forward, that person would remain non-exempt. So when they worked over 40 hours a week in the future, you'd have to pay overtime, which is probably not what you intended by hiring an exempt employee in the first place. And they're probably by their duties an exempt employee. So that's a risky proposition. I don't advise doing that. Record keeping is extremely important during this time. Now, of course, when you work with somebody on a day-to-day basis and you see them, you can calibrate when they're showing up, when they're leaving, how long their lunch is, and how productive they're being during the workday. And that's really difficult in this time of virtual work. But that's another reason why it's super important to have this active engagement so that you're more informed of what your employees are doing and what they should be paid. You don't want to find out that, one, somebody is working not enough and you're paying them too much, but you also don't want to find out that somebody is working overtime and you're not paying them, because that's a violation as well. You have to pay the overtime. So it's just very careful that you are engaged and you keep records. And you may discover that some people are more productive at home and might prefer to work at home on a regular basis. So it's a great time to find out how people work and how productive they are, but you have to maintain your records. That's extremely important. There is no break in the ability to do that or the necessity to do that. So let's talk about the EEOC. Of course, the EEOC is the agency that oversees many of the federal laws, including Title VII, including the National Labor Relations Act, and as we'll talk about in just a moment, including the ADA. And Title VII, as we know, is the law that says you may not discriminate based on sex, color, race, religion, or national origin. And so my caution here would be to all employers that you be very careful not to make a determination of COVID risk based on any protected category, but particularly based on race or age or country of origin. In fact, don't make any assumptions at all about who is at risk. If somebody's at risk, they're aware they're at risk, and there's no need to remind somebody, for example, that they're over 65. Any employment decision you make based on a protected status remains illegal. You cannot take those things into consideration. Now, what do you do if you learn that one employee is harassing or discriminating or making jokes about somebody's age or race or country of origin related to COVID? Well, the answer is you handle it as you would any other employment-related claim. And by that, I mean you do an immediate investigation, as immediate as possible in the circumstances, and you handle it thoroughly, promptly, and you make sure that is not occurring in your workplace. Now, if you do get an EEOC claim or a state agency claim during this time, you do have a good faith basis to ask for an extension of time to respond. I would do that early, and I would do that in writing. But the EEOC is probably going to be pretty reasonable about timing, and they understand investigations can't be done as quickly as normal, and that it may be difficult to gather the information that you need to prepare a response. So you can work with the EEOC. Now, the National Labor Relations Act, Section 7 of this is a law that applies to all employers, and many employers think it only applies to unionized employers, but it doesn't. The National Labor Relations Board has jurisdiction over almost every employer in the United States. And Section 7 applies to everybody. And what it says is that employees are allowed to discuss terms and conditions that are of concern to many people. And they need to be able to do this without fear of retaliation. And we talk about this in terms of the water cooler conversations. Allowing employees to do this, to discuss concerns that they have, is more important than ever for legal and for morale reasons. I think that employers need to be sensitive to the fact that employees are under stress. Some people are tired of being at home, particularly in parts of the country where the weather doesn't allow them to go outside at the end of the day. Many people are worried about money. Maybe they have a spouse who is not employed any longer. Many are exhausted from doing the jobs of a full-time employee and a full-time teacher and a full-time parent, and learning to do all this with brand new technology. So it's a great time if your employees come to you with concerns about the terms and conditions of employment. It's imperative that you work with them and have your HR people work with them to take care of them and to listen to their concerns. It's also, by the way, a really good time to look at your EAP, your employee assistance plan, if you have one. And if you have one, remind your employees that it's a great benefit and let them know how to use it. They may need EAP now more than maybe they ever have before. So as I mentioned, under the EEOC is also the ADA, the Americans with Disabilities Act. And as with the theme, all of the rules are still in place. The rules have not changed. However, some things are now allowed that were previously prohibited. And specifically what I mean is that medical exams and inquiries have not been allowed unless they are job related and consistent with business necessity. So that would mean prior to COVID, taking a blood draw, doing a swab, taking somebody's temperature would only be allowed when those things are job related and consistent with business necessity. And that would mean that the employee's actual or suspected medical condition could impair their ability to perform their essential functions, which is a really high standard, or that the employer has a reasonable belief that the employee poses a direct threat to his or her own safety or the safety of others, and that threat cannot be eliminated by a reasonable accommodation. So that is also a super high standard, but in March of this year, the EEOC, working with the CDC, declared COVID-19 a direct threat. So what does that mean? From on the ground, what does that mean? Well, it means that employers may take steps to determine if employees who are entering the workplace have COVID-19 because they know that an individual who does have the virus does pose a direct threat to the health of other people. So the new rule, which is limited to COVID-19, is that employers may ask questions of employees who report to work feeling ill or who call in sick. And that specifically, the employer can ask questions about their symptoms to determine if those symptoms are consistent with COVID-19. It also means employers may measure body temperatures. Now, the EEOC has said that this can be done at the offer phase and apply to applicants, but I don't recommend that. We'll talk about that in just a moment. But this also means that an employer may administer COVID-19 testing before employees enter the workplace to determine if they have the virus. But here's the thing, unless you're a physician, bear in mind that there can be false negatives, meaning the test results aren't valid or that the COVID-19 hasn't shown up yet on a test, but somebody could still have it. The second thing is there's no guarantee of a vaccination around the corner. I heard that the best case scenario for a vaccination or a vaccine would be the winter of 2021. So that's quite a ways away. The third thing is there has not been a year's worth of COVID to determine the seasonality of this illness and how it's going to interact with influenza. So my recommendation is that all medical inquiries be done post-offer, not pre-employment, and the better practice, unless you are in fact a physician, is to refer somebody to a medical provider. The other thing you have to bear in mind that makes it really just a little bit more complicated is that employers have to balance the privacy of an individual who reports whether they're ill or they feel ill. because they could run afoul of laws like HIPAA, which is the Health Insurance Portability and Accountability Act, or the state counterparts to HIPAA, or just general confidentiality and privacy laws. So you have to be very careful to protect the employees who do report that they don't feel well. Now, what about accommodations? Because accommodations is something we talk about with the ADA all the time. And this is, again, I can't say it enough, to communicate through the interactive process is really, really important right now. For example, if you're in a state where a face mask must be worn, if somebody needs an accommodation because perhaps they can't wear a mask because of a disability, you have to accommodate them. And the same would be true, by the way, for religious accommodation. And again, this just emphasizes this communication piece that's so critical. And then finally, as I mentioned, we want to make sure that there's the information is retained confidentially, and like with the other laws, there's no retaliation. So the ADA is a big, big part of COVID-19 with the interactive process right now. The CDC has been super, super helpful, and their website, which we have on our resource page, has great FAQs. They have a guidance for businesses and employers who plan to respond to COVID-19, and it's regularly updated. And following this guidance is really good for a couple of reasons. One, it creates a healthy workplace. But two, if you follow the guidelines, you may have a defense available if you are faced with some sort of tort or negligence situations like we spoke of earlier. You would be able to say, I followed the CDC's guidelines to a T, and that may provide you with a certain level of insulation. The guidelines goals are to reduce transmission among employees, to maintain healthy business operations, and to maintain a healthy work environment. And one of the guidelines overarching issues is to make sure the workplace is clean. So start by reading the guideline on cleaning and disinfecting. If you hire a professional cleaning company, have a conversation with them about whether they're complying with the guidelines. If they don't know what the CDC protocols are, I probably wouldn't hire that company. If you have your employees clean your office, you need to double check to make sure your employees are following the guidance as well. It requires gloves and certain PPE, like maybe gowns, depending on what you do, and maybe following any MSDS requirements, again, depending on industry. But regardless of who actually does the cleaning, as a business owner, you may want to take a walk around the office and just think about the things that are commonly touched. When I kind of did like a mental walkthrough of the office and thought about all the different things that are commonly shared, I was stunned at the number. And here are just some of the things I came up with. All doorknobs, a lot of chair rests, shared telephones, everything in the break room, everything in a conference room, remote controls, shared keyboards, shared iPad screens, restaurant menus, cell phones, sign-in pens at the front of a desk, elevator buttons, shopping carts. So whether we're talking about COVID, influenza, or just great hygiene, these are things that we should be cleaning on a regular basis anyways. And the CDC also talks about making sure your AC ducts, your air conditioning ducts are thoroughly cleaned and that you're using high-grade filters, because there are filters out there that you can purchase that are actually like the N95 masks that have the virus prevention screens as part of the filter. So because COVID-19 can spread from people who are asymptomatic, the CDC expanded its recommendation to include, and this is just a recommendation, having employees wear face coverings where they're in public settings where social distancing is difficult. And some states have followed suit. So for example, in New York, the governor's executive order requires all essential businesses and entities to provide any employee who is present in the workplace with some sort of face covering when they're going to be in direct contact with customers or members of the public. If you're in Michigan or California, New Jersey or Rhode Island, similar rules apply. So you're going to want to look at the rules, and even, especially like in California, drill down to the municipality, because some municipalities have specific rules for specific industries. So no conversation about reopening would be complete without talking about OSHA. And I'm going to talk about federal OSHA, but again, bear in mind that most states have some sort of state OSHA, and states can go above and beyond the requirements. So OSHA contains a general duty clause, and this requires that an employer furnish to employees a place of employment that's, and this is what the words are, free from recognized hazards that are causing or likely to cause death or serious harm. Now, this is intended to eliminate known workplace risks, but COVID is new, it's novel, and it's largely unknown. So OSHA's issued a guidance as well, and it is on our resource page, and it's on preparing workplaces for COVID-19, and it divides employers into risk zones. And the risk zones are very high, high, medium, or lower risk. And OSHA says that employers must provide PPE where it's necessary by reasons of the hazards in the environment. So if you think about like a welder who wears a shield over his or her face, that makes perfect sense. That would eliminate a hazard, right? But what about in non-traditional places like white-collar offices where people work in close proximity? Then you might really want to think, I mean, I'm thinking about like a call center where you have 100 people in a smaller room. Maybe masks are a great idea there. So OSHA will continue to investigate complaints of unsafe workplaces, and they do require that if you do have a COVID-related illness, you have to record it on your OSHA 300 log. Now, this would mean that there's a confirmed case, it's work-related, and it involves one or more of the other recording criteria, which means it's beyond first aid, for example. Now, the challenge is how to prove it's work-related. And I would go back to my example of a call center. If you have 100 people in a small call center and nobody's wearing masks, and 50% of the people become positive with COVID, that's probably going to be work-related. But if you have people who are cleaning and wearing masks and 2 people become ill, that's probably not going to be work-related. So you just want to look at where people are concentrated in small areas together. So we have talked, a lot in the past 6 weeks. I think this is webinar number 5, and we've had 4 webinars to talk about the FFCRA, the Families First Act, as well as the CARES Act. And I want to remind everybody that under the FFCRA, if you have employees who need tests, there's no cost sharing or deductible. So in other words, the test is completely covered by health insurance. Now, a lot of employers have asked me about job restoration. Do I have to restore people to their prior jobs? And the answer is that under the CARES Act, if you have fewer than 25 employees, you don't have to reinstate the employees after their FMLA period and you have to meet 4 criteria. The first is the employee was on leave due to a public health emergency. 2, the person's position no longer exists due to economic conditions. 3, the employer makes a reasonable effort to restore the person to his or her old job or an equal job. And then 4, and this is the big one, the employer makes reasonable efforts to restore the employee during the 1-year period after. So it kind of gives the employee a right of first refusal to have that job in the full year after the non-restoration occurred. So that's one thing to bear in mind about job restoration. And then finally, I want to talk about workers' comp a little bit, because as I said, it's really difficult to track how somebody gets COVID unless you've been on a complete and total lockdown and every single person that you have been around has been quarantined with you. Tracing COVID can be very, very hard. So it's unclear whether there's going to be workers' compensation claims by employees who become ill where the employee tries to make an argument that they can trace the illness back to the workplace. Now, there is a case in Illinois right now. We all know that workers' compensation in almost every state provides the exclusive remedy. And what that means is that if you get ill at work or you are injured at work, and it's an on-the-job injury, the employer must pay medical and indemnity, but in exchange for that, you cannot sue in tort. So you can't sue for negligence. And the only exception to that is where the behavior was so grossly negligent that it takes it outside of tort. So that's the general rule, and that's pretty much true in every state. So right now, there's a case in Illinois where a family of a decedent wants to take the case out of workers' compensation and sue in tort for wrongful death. And what happened was there was an employee who worked at Walmart, and he passed away from COVID. His family, normally passing away, if it were connected to work, would be a workers' comp injury. But his family has alleged that his employer, Walmart, did not exercise reasonable care to social distance, to provide PPE, to warn employees that other employees were ill, or to train employees on any safety hazards. Now, given how difficult it is to track transmission, I don't know how the employee can prove or even how the employer can defend this claim. The family is arguing, though, that workers' compensation should not be the exclusive remedy and that they should be allowed to sue for wrongful death in tort. So we're going to just have to see what happens with that, but that's something to definitely keep in mind, and that's a motivation, I do believe, for employers to make sure that their workplaces are as clean and as safe as possible upon return.
Amie, you did a great job in covering a lot of content quickly. Just a reminder to everyone that there'll be links on our resources page on our website. But I know, we can go through laws. It's really overwhelming to think about individual laws and then how they all work together and just being able to make practical decisions. And so what we wanted to do here is just compile a list of questions that we feel we've heard most frequently from our clients and from our communities, and really just give a chance, Amie, for you to go through some of these most frequently asked questions. So the first question, and Amie, sorry, I'm having something crazy happen with my screen right now. But my first question, I think, is the most common one we've heard. I'm preparing to get ready to return my employees to work, and I have an employee that doesn't want to return to work. What do I do? And there can be various reasons for that, and I think you outlined some there. Not feeling safe. Is the answer change if that person is homeschooling? What's your advice, Amie?
Yeah, so I wish there were one easy answer, but there is so not one easy answer. The first thing you have to look at is to determine if you as a business are subject to the Families First Act, which applies for employees who have 500 or fewer employees. And then the second phase to that is asking whether your employee has the ability to work or telework, and do you have work available to them? So if the person is unable to work or telework and you have 500 employees, then you have to drill down to the reason that they don't want to work. If the reason is because they're subject to an isolation order, because they're advised by their doctor to self-quarantine, or they're experiencing symptoms of COVID, then they're probably protected. If the reason is because they're caring for somebody, a family member who is subject to an isolation order, or who has been advised by a healthcare provider to self-quarantine, or because, and this is the big one, the employee is caring for a son or daughter where their child care or school has closed due to COVID-19, they might be protected under the law. Now, whether they have the ability to work or not is a huge thing. If you have work available to them and you've provided them with the means to telecommute, then arguably, whether their school is closed or not, they can do the work, and so they wouldn't be protected. But how much leave somebody gets and how much pay they get depends on the reason for the leave. So unfortunately, there's not a one-size-fits-all answer. But if you determine that somebody is not eligible for leave under the FFCRA. You can put them on PTO. If your policy allows that, you could potentially end their employment, but do that in conjunction with your HR or your legal counsel to evaluate your risks. You could put them on unpaid leave with or without a job guarantee of restoration, depending on what you want to do. But one of the overarching things that I think people may not be understanding is if work is available and somebody chooses not to work, they're probably not going to be entitled to unemployment compensation.
So Amie, next question. It takes my employee 5 to 10 minutes to get temperature taken and put on PPE before doing any work. Do I have to pay her for this non-productive time?
The answer is 100% yes. If you are requiring them to have PPE or if it's necessary for their job, that's called donning and doffing. And taking on and off PPE is compensable. And if you are requiring their temperature to be taken, even if it means they have to wait in line for 10 minutes, 100% yes, you have to count that as hours worked.
So we've reopened, and an employee who felt and appeared well now feels and appears unwell. I really need this person to work. What's your advice, Amie?
My advice is send them home. I would send the person home ASAP to recover. If you knowingly kept somebody at work, that might take you out of that workers' comp that we talked about and into negligence. You need people who are healthy. You need people to self-quarantine until they fully become healthy. Again, you would want to look at under your business, are they entitled to leave, to protected leave under the FFCRA? And then you'd want to take all the CDC's guidelines with respect to cleaning, including tracing where people have been so that you can track the virus if others get sick. You have to send the people home. Even if they want to stay, even if they say, gosh, I'm really sick, but I really need the money. And you say, she's really sick and I really need her. So you need to send them home. You've got to do what's in the long-term best interest of your business and the employee and the other employees.
All right, so this is a very common one we're hearing every day now. And my employee feels she has successfully worked from home during this period of time and now wants to know why she can't do it every day going forward.
I do think employers should anticipate this. I think they're going to get this question pretty frequently. If the request comes as part of an ADA accommodation, then you need to evaluate whether working from home on a part or full-time basis or rotating basis, for example, presents an undue hardship, or is it a reasonable accommodation? But if it comes as just a preference, a non-ADA request, then as the employer, you have the right to say what's in your best interest and whether you want to let somebody work at home not at all or 100% or somewhere in the middle. But if you do choose to allow somebody to work at home, you should 100% have a telework agreement in place to make sure that everybody understands not only the wage and hour rules, but the safety rules and the work expectations and the communication expectations. But you as the employer get to make that choice.
Yeah, I think this is really where we'll see the blending of compliance versus culture, right? What kind of employer are you going to be from a flexible and remote work strategy moving forward? And we have a lot of clients that are exploring that right now. So, all right, question number 5, and this is a really good one because, you know, I feel like we have so many well-meaning clients that have called us and said, hey, I have big concerns about my employees that are older, or I know that someone's recovered from a serious illness, or I know someone's pregnant, and can I just tell them not to come back? Can I just send them home?
That would be age discrimination, pregnancy discrimination, disability discrimination, whatever, whether it's somebody 65 or pregnant or immune compromised. That would be all sorts of discrimination because, again, somebody knows they're 65, they know they're pregnant, and they're entitled to take ownership of that themselves and make the decision for themselves if they want to work or not work. And that's true whether we're talking about COVID or whether you're talking about a job that you just believe is unsafe for whatever reason. You need to let people take ownership of their own decisions. So I do have some practical advice, and this just gets right down to the nuts and bolts. First is, as Kara just said, to be super flexible about schedules and the need for time off right now. Technology can be your friend, and the question is, what kind of employer do you want to be, and what do you want your culture to be going forward? With respect to flexibility, most of the world has children at home right now until August probably, as schools and summer camps are closed. And so employers need to be very flexible with their best employees, with all employees, to make sure that they can retain those and motivate the employees to do their best. That's a win-win. And when you're considering opening, I would suggest staggered openings to keep fewer people in the office. I know when we were in the closing process 8 weeks ago, we had one department come in on Monday, Wednesday, and Friday, another one Tuesday and Thursday, another one came in Monday and Thursday, and that really limited the number of people in the office. And so maybe it's that, or maybe it's employees by last name who come in alternating weeks, or maybe you have certain production lines work from 8 to 1 and another one work from 1 to 6. But whatever it is, make sure you're using legitimate, non-discriminatory reason for allowing some people to work and some people not to work, or some people to work from home and some people not to work from home. Same thing with breaks. Consider staggering your breaks and your lunches to avoid large groups congregating. Clean everything. If you have an employee where a mask is not required, but it makes the employee feel safer and more comfortable, right now I would suggest letting people wear them. And you can set certain parameters on masks so that they don't contain offensive words or offensive images and things like that. But where people feel comfortable, it's a good idea. And then where practical, use virtual work. I mean, again, this is our test run for hurricane season and lots of other things. It's going to require a lot of supervisor engagement and regular check-ins, but Zoom and similar platforms are your friend, and they can help people feel connected. And then finally, my favorite piece of advice is to use outdoor spaces for meetings, for lunches, especially if you live in a place like our beautiful Panhandle where the weather's just wonderful. Use your outdoor spaces so that people can be outside in the fresh air working.
That's all great advice, Amie. And, we're getting close here. I think we've got just a couple of more minutes. One thing that we've heard over and over again in the last few weeks is concern about employees not returning to work when an employer is ready for them to return. And one of the particular topics that employers have brought up to us is their concern that employees that have been collecting unemployment insurance could potentially be making more collecting unemployment and will not want to return to work. And I know every state has different policies, and we certainly have the federal unemployment policy. So I wanted to ask the attendees one more question on the poll of your concern about if the generous state and federal unemployment policies are going to discourage employees from returning to work, based on your opinion. So just a quick minute here to get some responses, yes, no, or unsure. Really interesting here on our responses here, almost pretty even between yes and no. So interesting results. And I know that probably depends a lot on location and also a lot on your industry. So we have just a minute or two for a couple of quick questions. And Amie, we got a lot of questions around taking temperatures at work. Or asking employees to complete a survey every day on how they're feeling or symptoms. But one of the things I wanted to highlight with these questions is we had an employer say, I have an area of the company where the employees are kind of more densely located versus other areas, and can I only ask that group to take their temperatures?
Gosh, that's a great question. As long as there is not a disparate impact on age or sex or race or any particular protected group, I would say you can do it based on, it seems like using the call center, but not the whatever office suites or whatever, would be a legitimate way to divide people up. But you want to make sure you do every single person who's in that selected group, and not just the people who are over 65 or the people who are whatever.
Yeah, well, I hate we're out of time. I would definitely like to have covered more questions. I know we'll be back, and there's going to be so many practical questions like the ones we already discussed today on, you know, how we get the ball rolling and get people back to work in a safe manner. And I know we're also anticipating guidance on for those attendees that have received a PPP loan on more about the loan forgiveness. So we'll definitely be back with that information too. So thank you, Amie, so much for all of your great content. Thanks to everyone for attending today. Everyone that registered will be receiving a recording of this webinar, and stay safe.